Good afternoon, everybody. Just want to thank you for joining us today for the legal landmines and franchise transactions. I'm Tim Whaley. I'm one of the partners here at Dominion Payroll. I focus on our strategic alliances, and I'm glad you could join us. We're excited today to be joined by Jack Santinello and Nick Stack over at Shumaker Law, and they're going to lead us through common legal pitfalls in franchise, M&A, and investment deals. They'll share practical strategies to reduce risk, protect your brand, ensure a smooth and compliant post-transaction integration, all while preserving those crucial franchise relationships. Before we get started, just a quick reminder, we are recording this session, so you will receive a copy of it after the presentation. Jack, Nick, no pressure. If you have any questions, please post them in the chat. And then at the end of the presentation, we'll go over those. So without further ado, Jack and Nick from Shumaker, Loop and Kendrick.
Great, thank you so much. Appreciate it, the opportunity to come share a few things about franchise transactions. So a little bit of background. So I am a corporate transactional M&A lawyer, and I've been doing this for over a quarter of a century. And about 2 decades ago, started moonlighting in the franchise world. I was voluntold as a young associate that this is something that I should do, and of course, that's what I did. And so, and it makes sense in that it is, franchising is a particular type of business, and but as you'll see as we go through the slides, that there are a lot of peculiarities with respect to franchises. I have my partner Nick on with me, and I will share. So these are snippets of our bios, but basically what it says is, as I said, doing corporate transactional M&A, franchise lawyer. Nick is on the litigation side of things, and so I jokingly said to Tim before we went live that I start fights and then write nasty demand letters and kind of thing, and then Nick yells at me, and then he goes and cleans it up and fixes the things. I've been a little more disciplined in the recent decade or so in not necessarily and asking necessarily for permission in some cases, but bringing him on early on and staying in my lane. So and why I wanted to have Nick as a part of this is that so that you get the litigation aspects of some of the things that we're talking about on the transactional side of things. So seeing maybe some of the effects of things that happen, good or bad, in the context of litigation. So basically want to start with what are our goals for today? And basically it is to ideas on how not to give away your company's cash in the form of mistakes, which then generate liabilities. More pertinently, ideas on how to reduce risk and ideas on protecting the brand. So I know what's on your mind. You're thinking, hey, Jack and Nick, what are you guys going to chat about? And there's actually a misspelling that my marketing person just told me that there's a word missing in that, so I apologize for that. Didn't have a chance to change it. What are we going to talk about? So we'll start with talking very briefly about the regulatory regime. There's a lot of rules out there that impact franchisors, franchisees on the federal level and on the state level. And we'll talk about consequences if you don't do those things, particularly from a franchisor's perspective. Why are franchise M&A deals unique in comparison to non-franchise deals? As I said, some people view it as a subset, some people view it as totally different, but I really believe that if they are two circles that overlap each other in various aspects. So the things that are comparable, there are things that are contrastable, and you'll see that. And then common legal pitfalls in franchise M&A transactions. And then we have some checklists that we'll go through with you. So let's start with the regulatory regime. And I apologize if this is remedial to anyone out there listening and watching, but I think it's important that everybody have a baseline understanding of what what is out there as far as the rules go. I will tell you that Nick and I a couple weeks ago did an entire presentation just on things like this, the regulatory regime and sales compliance when franchisors are selling to prospects. But so you have basically this regulatory regime, which is the federal regulation called the FTC franchise rule. And what you have is you have this disclosure document that you give to others, to your prospects, that is the good, the bad, the ugly. This came about similar to how it happened with the stock market and stock exchanges back in the 1930s, since we have a 33 Act and a 34 Act that says if you're going to take money from strangers, you need to tell them the good, the bad, the ugly. Similar things were happening in the franchise world where you have franchisors that said, hey, give me your money and I promise you a rate of return. So because of those abuses, they said, we're going to do the same thing. So you have to provide this document 14 days before, some states 10 days before you actually sign the franchise agreement or receiving payment. Date of delivery doesn't count. That's more of a technicality. And again, that's to ensure that your prospect franchisees that you're taking money from have all the information they need before they commit to you. And then understand that the federal government doesn't review this magical, mystical document that you are presenting to others. They are basically saying you need to follow these rules. And so you're talking about disclosing it properly. But that's not the end of the story, because then you have state regulation. There are 13 states that say, in addition to all the stuff you're supposed to be doing on the federal level, you need to do these other things. So you cannot terminate whenever you want. You have to do certain things. You have to you can't say that we will increase your rate as we determine in our sole discretion. You have to tell them how much you might increase your royalty rate, your ad fund rate for the period of time during the term. And then that's not the end of the story either, because then you have other states that you have to, that are called filing states, that you need to basically send a piece of paper to and say, hey, pursuant to the Constitution, we are doing what is required pursuant to federal law. So states, you don't need to mess with us. And the states say, okay, just let us know. Those are the states that are on the left side of the screen: Connecticut, Florida, Kentucky, etc. North and South Carolina have a modified version of that, of what needs to be done. And then Georgia is not technically a filing state, but you need to be doing a few extra hoops with respect to your disclosure document. All right, and this is just basically a summary of the chaos to show you that there are more than just a few states that you have to, that franchisors have to jump through for extra hoops. All right, what are the consequences for non-compliance? So that is rescission. Okay, fancy word for basically pretending like it never happened and put everybody back to where they were on the day before the transaction closed. So that means basically, as I said, canceling the contract, reverse the transaction. Restitution is part of that, which is, okay, franchisee pays 50, 100, $150,000 in initial franchise fee. They get that money back and you get your operations manual back. And it's obviously more complicated than that, but that's basically what we're talking about in the scheme of things. So again, return of franchise fees, the franchisee returns the confidential information, termination of ongoing obligations, and then if there's some bad stuff going on, then that may be pursued either by the franchisor or the franchisee. So this isn't a necessarily get out of jail free card for a franchisee that has a franchisor who didn't properly comply with all the rules that they were supposed to comply with. All right, and then just some other stuff. All right, so again, why are these type of deals unique to other in comparison to other business transactions? From the franchisor's perspective. So just so you know, the way that we structured this was we're going to talk about the franchisor's perspective, franchisee's perspective, and then we're going to add on a bonus round in some of the later slides, which is what does it look like as between maybe a seller, a multi-unit seller and a multi-unit buyer. So why is it different? So we're talking about not just two parties to the transaction. You have other people in the sandbox that are playing with in the transaction. So you have suppliers, the regulators, and others. And this has an impact not just on the transacting parties, but throughout the system from the franchisor's perspective, and quite candidly from the franchisee's perspective. Regulatory overlay, we just went through all of that, so I won't you know, basically be stuck on that. I also should say that I know that I'm talking with a little bit of speed. I normally would talk like this and going through a presentation, but there's a lot of material. I also have to admit something, an admission against interest, and sorry, Nick, for doing this, but I had put together this presentation and then I said, hey, ChatGPT, this is what I got going on. I'd like a few more bullet points on on the various topics that are talked about in here. And then it went nutso and then gave me a lot more of information. So I had to dial it back. And there's some things in here that I was like, oh, yeah, that's probably a good thing to mention, kind of thing. So understand that while I am taking credit for being the original author of the core of this, that there are some things that may have been included complements of artificial intelligence. So again, regulatory overlay, we've talked about franchise agreement, transfer and consent rules. We'll talk about that as well, but be aware that there are rules that are within the documents that you have signed that will say, can you transfer? What are the rules? Who has to consent? Who you don't need consent for, kind of thing. Ongoing relationships. So in comparison to, and I put, one and done asset sale. That is mostly true, generally speaking. So you have, and there may be a tail to it where the original owners, the sellers, have obligations, maybe a consulting agreement, maybe there's an earnout. So yeah, those kind of things. But the franchise relationship is more of a long-term relationship. And so that gets inherited by a purchaser of the franchise system. And, as we'll talk about in a moment on the franchisee side of things, there has to be a continuing relationship and a new relationship, but it needs to be continuing. Brand and system protection. So, in these transactions, what really is a franchise system? It is, at the core of it, the intellectual property, the know-how, the operations manuals, and certainly the brand, the trademark, which is the paramount asset of a franchise system, is your intellectual property rights in your trademark, the words, the symbols, the slogans, the logos, those kind of things. So if this isn't handled properly in a transition, then, and we'll talk about kind of a due diligence list later on, that those things need to be considered as you're going through this type of transaction. And then impact on the economics and the financials. New owners, are they going to bring, are you, as a new owner, are you going to bring in, change in the royalty structure, change in that advertising regime, the method of advertising? So it may be that you have kind of old school, really kind of maybe even the email campaigns and those kind of things, but you haven't implemented AI into certain things, or you haven't really accessed, maybe Instagram is a good way to get the word out. Maybe, you should be advertising on, other platforms that didn't exist at the time when the marketing campaigns were created originally. So those kind of things need to be looked into as well, or considered. Again, IP is the core asset. I'm not just talking about the logo again, but the brand manuals, the know-how, and not just the know-how that is written, the know-how that is in people's heads, whether it is the general manager, if the C-suite, all those people that have knowledge and have implemented the business model into the franchise system. And then IP ownership and licensing must be crystal clear. Maybe not a surprise to many of you that you have situations where we go through due diligence when we're representing the seller, and there is, oh, well, you didn't file your renewal, or we have found somebody that's been using the mark and you haven't enforced it. So now there's a problem of whether or not you do still have that monopoly on the intellectual property. So, those things need to be considered as well. So I'm going to take a break and let Nick go through some of the on the franchisee side of things.
On the franchisee side of things, yep. Thanks, Jack. So just again going through kind of the basic information here, knowing that it might be a little bit remedial for some of you, but even if you're a franchisee, I mean, all of this regulatory compliance certainly still touches you. Even if you're not the one selling, all of the registration laws, these state laws that protect a franchisee's interest, still governs whether you're talking about how a franchisor is communicating with you, or the changes that are being made. You should absolutely receive an updated FDD if any material changes occur. So if your franchisor is thinking about selling and starts initiating that process, you certainly want to be advised if those material changes are coming, because that will affect certainly the way that you do business. Now, with any change in ownership in any business, and there's a risk of operational disruption here. New franchisors, new operating entities at the top level have their own ideas. Certainly, if they're looking to purchase an entire system, they know what they want, and that can mean things like supply chain changes, training issues. You might suddenly get, in the transition, some inconsistent brand enforcement. And because, again, that's really sort of the value of these systems, at its base, you certainly want to make sure that you're being taken care of. Multi-unit operators are obviously more exposed to. Now, this is certainly part of the practical thinking here, and this sort of permeates the entire process, including some of the litigation parts of it. But you'll see shifts in support and culture, and new ownership might mean new people at every level, changes in marketing strategy, and they might try to change the technology system too, whether that's to save money or because they think they have more efficient ways to go about the business. It can be positive, but certainly can be negative too. So franchisees just want to make sure they keep their eyes peeled and really digest all of the information coming through this whole entire process. Right. So then you're looking at your bottom line, the economic impact of these deal changes. While the royalty or marketing fund terms usually can't change in the middle of a contract, keep a lookout for those renewals, or if a franchisor, a new franchisor that is, wants to push forward amendments. Again, these guys probably have their own sense of what they want the franchisor system to look like, so you want to make sure that that is consistent with what you've been sold. Looking forward, we got brand reputation and system stability as well. A franchisor with a poor integration plan can erode that brand value, and that's going to impact all of the franchisee units. So want to make sure that there's an open line of communication to the extent that you can have any impact on making sure that brand value doesn't erode. Again, multi-unit operators have sort of a little bit of a more skin in the game perhaps with this, so maybe they have a bigger voice. And then opportunity and leverage. Again, well-capitalized new owners here can expand aggressively, which can create new opportunities, but can also have their pitfalls as well. And I think, as I just mentioned, strong operators have more leverage to negotiate. And then here we go, not in the perhaps mergers and acquisition sandbox, but certainly right next to it. We've got a deal between franchisor and the buyer. Now, it can alter your fees, support, territory protections, and brand reputation, and that can happen really overnight. And you have limited legal control unless your franchisee, franchise agreement grants those rights, and you got to make sure you know your rights as they're delineated in those franchise agreements, because it's just that those four corners of that relationship really control.
And I'm laughing out loud because sandbox is one of my terms that I use a lot in transactions. And so you paused for a second. I wasn't sure if you were actually going to say it or not, but thank you for playing in
Yeah,
my sandbox.
yep, I had to, Jack. We're a team, of course. So next in line here, you got contractual protections and restrictions. In a lot of ways, franchisee consent is required. So you want to make sure that if you have those rights, you exercise them to make sure that you're comfortable with any transitions that may happen. Or conversely, you want to know if you don't have any say when a new franchisor is out there being selected. And then, of course, again, multi-unit operators just have to make sure if you've got different agreements related to different units, whether or not those rights are consistent amongst those stores.
All right, so let's talk about some common legal pitfalls in the franchise M&A context. Again, starting from the franchisor's perspective. So you have incomplete due diligence. So you have data gaps, and you have buyers that are not getting all the information they need. And it's not necessarily, it's not purposeful, but it is, just kind of sloppiness. And so kind of cleaning up the webinars that Nick and I and others do in relation to kind of best practices for businesses always include this, which is, you need to have your back office intact, or organized and properly vetted and operational, not just in an M&A context, but just generally speaking. And a lot of times that gets forgotten because we're dealing with the front office stuff, which is, all the things that normally need to happen in a business, like selling goods and services kind of thing.
Yeah, it's certainly important to make sure that sometimes that back office data in particular, there's sometimes I guess a little bit of deferred maintenance on those back end, shoring up that data. So that's important because as we see frequently in this context, what could have started as a little bit of a back office data backlog, that can come forward and be termed misrepresentation, whether negligent or intentional. And that comes up a lot in litigation context.
Yep. And then, franchisee settlement and litigation, ignoring franchisee morale or ongoing litigation. I mean, know your constituency and know kind of what's on their mind. Don't make assumptions that just because no one is yelling at you via email that this is not a good idea, or they're having issues, that know, again, your audience, know your constituency. And then vendor and supply chain risks. This is just something that continues to come up, not just in this context, but when we talk about issues of tariffs and inflation and everything else, and then being reliant upon, let's say, a supplier that is going to be hit with high tariffs from the country of origin. So, don't be overly dependent upon any particular source. I've suggested that, and we have clients who have entered into contracts with alternative suppliers and I call them option contracts, where they know that they are second, third, fourth in line in case of emergency. Break the seal in case of emergency, contact us, and we have enough supply that we can continue to supply our main customer, and we can supply you guys, at least at this capacity, to make sure that you have the appropriate inventory that you need in case things go really badly. And we can't really, and this is more editorialized, it's not political, but it is that, all this back and forth of, what is the tariff rate for China? What is the tariff rate for this? We have clients that have told me, that are suppliers, that shipment that comes in today, they are being told by customs as to what needs to be paid to release those out of the purgatory that they're in. They get another shipment next week, same amount of goods in the same crate, and it's subject to a different number. And it's just chaos. And so, again, understand your chaos in all of that. Overlooking compliance, again, we're talking about tariffs and those kind of things, but specifically in the franchise context, change of ownership, as Nick has said, will require certain hoops that you need to jump through with respect to your documentation, and then inconsistent item 19 FPRs. And those are the numbers that franchisor presents as past performance of company owned, franchise owned, or both. And there are very strict rules on how those are presented in an FDD. And now you're starting to mix numbers that are owned, meaning operated by the seller versus operated by the buyer. And there needs to be a way to distinguish those numbers under ownership so it's not misleading. All right. Poor change of control planning. So you have, and this is just a natural evolution of documentation. And Nick, you probably can speak better to this when you're going through and dealing with, okay, well, wait a minute, you have a multi-unit franchisee that has the 1995 document that has gone on a 30-year term, whatever it may be, and then they also have these other ones that have more recent, and they're different. And it's because back then they didn't think about things like changing control and those kind of things, and it just is an organic growth into the system necessarily. Okay, so consent hurdles we've talked about, development schedule conflicts. So with multi-unit, and we use multi-unit franchise owners and developers kind of interchangeably, that you have the schedule, and now there's been a change and it's right in the middle of the schedule. So, are you going to be able to complete that schedule? Is your franchisee going to be able to complete that schedule moving forward? And so having those discussions in before the transition is more appropriate and safer. Underestimating post-closing integration challenges. So not just culture, but I talk about the electronic culture. Are the systems going to be compatible? Have you been told by the IT people they're compatible, but there hasn't been any beta testing to see if the data that is on one side, meaning the seller, can be integrated into the buyer, or can they coexist? And if they coexist, is that efficient? Am I going to have to go to one app or one screen or one program on my computer to access old data? And then what happens when you're trying to aggregate the data for purposes of, again, reporting in your FDD and those kind of things? So field support, all the things that are operational in the field that need to be integrated and need to continue on, because the expectation of the franchisees is that it will continue. And then brand consistency risks in a transition to make sure that the whole concept of franchising in McDonald's is any of those are example, is that you can get a burger in New York and it's the same burger that you're going to get in California. Now, if you go overseas, the ketchup may be different because they use different ingredients for their ketchup packs, kind of thing. But you want a Big Mac, you're going to get a Big Mac that looks like the one you got when you were in the United States. So, those things kind of get a little loose in a transition. And so those are some things to be aware of in that context. Franchise relationship management. So keeping everyone informed as to what's going on and saying this is the transition plan, and not throwing it on them at the last minute. And I mean that figuratively. And say, even though the contract says they have to go along for the ride because that's part of their franchise agreement, bring them along for the ride, but keep them knowledgeable about where you're going, and provide them a map. And so ignoring key operators, those ones that have grown in the system and feel like they should have a voice, and that your success as a franchisor has been codependent on their success as a franchisee. You need to make sure that they are engaged and in the picture and in the process, so long as they're not disruptive to the process. Transition incentives, acknowledging that it's going to be a bumpy road, or potentially could be a bumpy road. Let me say that differently. Hey, franchisee, we're going through this process and we're going to do everything that we can to make this as painless as possible, but understand that there's a lot of moving parts, and it's going to be a little bit bumpy, but please tell us where the bumps are in the road so we can address them and move forward, because we want to continue on with that relationship. That's a conversation that both the seller and the buyer should be having with the franchise ecosystem. We've touched on this a little bit as far as regulatory and state law tripwires. Again, certain states have certain rules with respect to transferring a franchise system and what can be done. And then there's also, let me digress for a moment. There is things within that are within the law, and there are things that are equitable. And you have to consider both of those things. And so when you start talking about good cause and fair dealing and what's going on in the transaction, and for example, in the franchise agreement, it will say that if we sell, you go along for the ride. What it also could imply is you have to go along for the ride and you have to bear all costs associated with that. And let's say that in this process, there's going to be some high cost to the franchisees about that. Pursuant to the contract, you can do that. But might there be something else in the form of equity that says that it's not fair to do that to your franchisees? So those are those kind of things that are considered, and that is evolution from case law, not necessarily what's in a statute or a regulation. I went out of my lane there for a moment, Nick, so make sure that I stated that correctly.
I'm keeping tabs on you, Jack.
Okay. All right. So, Nick, if you'll go through kind of the other side of things with respect to, similar concepts, but from a different perspective.
Yeah, absolutely. So, when we're looking at this from a franchisee's perspective, part of it is to sort of make sure that you understand what the new franchisor's expectations are, and how it may change or want to operate the system. So, when a franchisor is looking to, or a new franchisor is looking to acquire, a franchise, they're usually focused on what the franchisor's financials are. And that can lead to overlooking the franchisee level compliance and the trends there. And what's under the hood? You got the top level finances, but that can typically mask what's happening elsewhere. Now, in the legal sense, you might have a good record of defaults or other disputes in the system. And if that's the case, you already know that the new franchisor is probably going to have just a heck of a time trying to enforce, some of the other brand regulations or anything else in the franchise agreements post deal, and you have to be aware of that. And then, other litigation trends and regulatory inquiries are also kind of at stake here too. I mean, I think the overarching topic here is whether or not the franchisor knows what he's walking into, right? Because that's going to affect how the franchisee deals with the new franchisor, and whether or not it's going to create some avenues for litigation if the operations are disrupted. So really, I mean, if the new franchisor doesn't have complete due diligence on the franchisees at the franchisee level, the current franchisees want to know that to see kind of what can happen going forward. All right, and then this is kind of going back to what Jack was talking about too, and that's really the franchisee needs to know its rights, and that starts with what kind of deal are we talking about? Is it an asset sale, or is it a stock purchase agreement? Because a lot of times, if a franchisee has rights in this area, it's going to be because it's an asset sale, which if your particular franchise agreement calls for it, you may have a consent provision there where it requires your consent in order to make that deal happen. Stock sales can typically, be the situation where the new owner just sort of slides in place of the old owner. But just make sure your franchisee is really taking a close look at those agreements, because that can still trigger obligations, but more or less typical. And that all has level impact at that franchisee level as well, because for instance, these asset deals, if the buyer tries to, again, buyers have their own expectations. They may well think they can renegotiate some of these contracts, whether that's vendor contracts or the renewals for your franchisees. So just make sure you're really well aware of what your franchise agreement says in particular. And then kind of just dovetailing on that, you've got your failure to address those change in control clauses. So just make sure that, again, you're well aware of what those clauses say, and here in particular with respect to, does it affect your territory rights or your development rights? Undisclosed liabilities. Again, I mean, if a franchisor is doing its due diligence, new franchisor is doing its due diligence well, it's going to be well aware of these things, or it should be. But typically, you might find that a franchisor isn't enforcing its rights, whether through sending default letters or taking franchisees to court to collect some of these unpaid royalties and marketing fund issues. But if from a franchisee's perspective, if those are underfunded and the new franchisor doesn't know about it, that's going to cause a significant issue and potential disruption going forward. And then we get, of course, to brand dilution risks. That's something you want to keep tabs on. Make sure you know your rights under your particular franchise agreement, because new owners bring with it just new opportunities, but also new opportunities also for some of these pitfalls, new culture, new leadership, and then as Jack, I'm sure, is going to talk about here in a second, a lot of other issues that are specific to those multi-unit owners.
All right, let's do it. All right, so I understand. I'm trying to share information and understanding that this is a diverse group of business owners that are on the line, whether you're from the franchisor's perspective, franchisee, or multi-unit. There's also the interaction in M&A transaction as between multi-unit owners, and including single owners that are maybe expanding into multi-unit. So sometimes there is this misunderstanding or about what it takes to go from company A to company B, to owner A to owner B, and all of them are going to require franchisor approval, obviously, and what is required from the franchisor or required from the parties in order to approve that. I would say kind of generically that it's the same process that any other prospect franchisee would go through with respect from the franchisor taking a look into this. When it is two franchisees that are already in the system, there is, I think, a competitive advantage in the form of economies of scale, in that the buyer knows what they're getting into. But again, franchisor may impose conditions and say, okay, you can buy, but you have to do these certain things, and that may or may not have been disclosed in the disclosure document that was received, but that is a condition to transfer. And the reason why that is permitted outside of the FDD is that that is related to the asset transfer and not necessarily to the offering of the unit to begin with, because as you might imagine, if you're the original franchisee and you're building it from the ground up, you're going to have those construction costs. So upgrade costs are derivative of that, and likely less expensive than a complete build from ground up. So that's why that works outside of disclosure. Timing risks, and so a lot of things that are out of the control of the contracting parties with respect to just various things, with respect to like the upgrades. SBA loans, those kind of things that come into play. Again, in all M&A transactions potentially, unless it's completely seller financed or a cash deal where there is no lender. Incomplete preparation of financial and operational records. As Nick mentioned, in the due diligence process, presumably all of this has been reviewed, all of this has been provided. When we do M&A transactions, we have a virtual data room. In the old days, when I was much younger, they talk about bankers' boxes. Those, for those of you that are older, understand that those were actually boxes that had stored paper information in them, and we would go through them page by page and document them, and um, you know, document the important ones and things like that. Now everything is electronic. And in fact, AI can go through reams of paper and pull out the important information once you tell it what the important information is. So, talk about how this impacts the transaction with respect to accurate financial reporting, with respect to top line gross revenue, EBITDA, could impact the multiple that's being offered in the transaction. So those kind of things need to be considered. Operational compliance. So, we've talked about this in the context of franchisor and franchisee. So same thing, what's going on in the businesses? Are there issues? All those things need to be disclosed, and hopefully have been disclosed pursuant to a appropriately drafted and robust due diligence request, and then also what has been produced in response to those requests. Transfer fee and upgrade surprises. Hopefully not so much of this going on, because the franchise agreements will be very clear about that. But what typically happens is, who gets to pay that? And sometimes in the LOIs, those are missed until the end, where the obligation, franchise agreements really don't necessarily say who pays it. But because it's in the current franchisee's agreement, it is maybe assumed that the selling franchisee is the payor of those transfer fees. That doesn't have to be the case. And so that is a point of negotiation, which should be done at the LOI phase. Mandatory upgrades. So again, we've talked about this in the context of, okay, what needs to happen in the eyes of the franchisor in order to get that transaction across the line. And then don't forget about the other people that are involved in the business, meaning the people that are implementing the franchise, your employees. So, staff retention. Are there non-competes in place for, let's say, the managers? Buyer wants to know that the people are not going to bail on them, and if they do, there's consequences. They can't open a competing shop in the same shopping center and those kind of things. So, and then lease assignments. Many times, as Nick knows, sometimes this is like, yeah, we're having a problem with our landlord. We're about ready to close, and they're not providing the assignment to the current lease or a new lease. And we just all assumed that they were going to be super happy with the new people. They've gone through the credit checks, and we just haven't received their blessing. And so our suggestion to you is, please do not wait until later in the process to make all those things happen. I do, and we do appreciate the fact that the lesser people that know earlier on, the better off it is, especially in the employment context. It's like, okay, I don't know if I'm going to like the new owner, or am I going to have a job? Am I going to get fired? Maybe I should be looking for another job, just in case they're going to trim down the number of employees that are operating this particular franchise. So there's the considerations there. A few more, again, underestimating due diligence by the buyer. Our recommendation is, and in line with what I said previously, is have everything in order, have the back office in order, not just for a potential transaction, but for your own peace of mind, and that you are there ready and available. Opportunity may strike, and if you're not ready, then you may miss that opportunity. So, we've seen a lot more aggressive due diligence into things like intellectual property, like data breaches, like, tell us about your relationship with your customers, with your clients, those people that you serve, and vendor contracts. So on the other side of things, people that are supplying to you, and as I said before, diversity of source of the raw materials for your business, whether it's food ingredients or other just inventory that you sell, or items that are required for you to run the business, kind of thing. Overlooking post-closing obligations. So, make sure that, and this is a pro buyer comment initially, which is make sure that you have your seller under these post-closing obligations, that it's clear what the non-competes are, not just what's in the franchise agreement, but what's in your transaction agreement, whether it's an asset sale or a stock sale. So that's why I mentioned, the non-compete restrictions that need to be clear. On the other side of things, if you are the seller, you don't want to be beholden to an overly aggressive restrictive covenant, even though you might think, or your attorney might think, that that is unenforceable. So, no harm, no foul. I would not rely upon taking that position in analyzing those post-closing operation or obligations. Relationship management. So, think about franchisors, and again, you probably have more favored nation status if you're already in the system. And so, obviously franchisors will have their own standards and objectives as bringing on someone new into the system. I would also say, and this is kind of a random thought because it's come up, which is, don't assume, well, take a step back. Franchise agreements usually have a right of first refusal in favor of a franchisor. So, you probably want to make sure that your franchisor is not going to say, hey, we're in. And after you've gone through all the song and dance and the romance and the wining and dining of your potential buyer, that you have this issue that the franchisor is going to swoop in and take that opportunity away. Maybe okay. I mean, if they're offering the same or similar to what you're going to get from this other party, then maybe okay, but sometimes not. So for example, franchise agreements will have maybe more favorable terms for the franchisor buying. Maybe they can pay you in 5 years, so a 60-month promissory note with maybe a little bit of cash up front that you've agreed to, maybe unbeknownst to you, because you didn't get to that page in the franchise agreement dealing with transfers because you're thinking, that's not going to apply to me. So that again happens, and I'm not trying to be flippant about it. I mean, it's just, it does happen. And so it's also a reality that many people, including myself, when I'm looking at contracts for whatever it may be in my personal life, get lazy and don't look at the last 2 pages of a contract. It's just kind of boilerplate, and it is what it is. Communication timing. So again, I've just suggested that you let the franchisor know, but I think you should also have things far enough in line to be able to go to the franchisor and say, I have a bona fide offer. But you got to be careful about who you tell about that, including your brothers and sisters franchisees that you're friendly with, because I've seen how this has a ripple effect. It's like, oh, wait a minute, I was thinking about selling too. I need to get going with that, and it may mess up your own deal, possibly. All right. M&A legal checklist. Nick, do you want to go through?
Yeah, I can rattle
Start
off
on that.
rattle out franchisors, unless you want to take the franchisor, Jack.
All right, I'll do that. Again, this is it's this kind of similar information, just put in a different format to get you thinking about it, repeatedly. So pre-deal preparation. So make sure the financial aspects of the deal are in place and properly in place, that it's understood. I'll give you an example about some of you may be familiar with Section 1202 of the tax code. That basically says that if you are a C corp and properly structure your business and wait 5 years before you sell your business, then if you make a bunch of money off of that transaction, like millions of dollars, you do not have to pay the federal government a penny of tax. Now, there's a lot that goes into making that happen, including having to hold it for 5 years. Now, with the tax bill that just passed, there is a 4-year stopping point and a 3-year stopping point. So prior to recently, it was a full 5 years. So understanding those kind of things that go into and potentially are tax advantageous. And we've talked about this, review change of control provisions in the franchise agreements that you've signed up with your franchisees and your master franchisees or your developers. Identify the required consents of all of the players in the sandbox. Assess state registration requirements and timing constraints. You want to know what's going on in your timeline of filing in these registration states and if there's going to be an issue. You plan communication strategy with and for franchisees, key vendors, and regulators. Again, letting people know what's going on that are required to go along for the ride or maybe have an option. So for example, key vendors, maybe you don't have them locked into a contract and or maybe there's a change in control provision. Understand that when I say change in control, I mean two things kind of wrapped into there, which is a true change in control of the entity, but then also anti-assignment or assignment restrictions of the actual franchise agreements. So I kind of lump them into, are there any barriers to getting those contract rights from seller franchisor to buyer franchisor? Great. And then franchise specific due diligence with respect to what you have in your files. You know, has everybody been properly disclosed? You know, is everybody registered? Are you registered properly in the registration states? What's going on with respect to your franchisees? Is there a problem? Has there been threats of filing a lawsuit? Are people ganging up on the franchisor? Is the possibility of putting together a franchisee association on the horizon for good and bad reasons from the franchisor's perspective? You know, what do you have going on as far as training? Is it sufficient? Are there material weaknesses in the training that bubble up down the road because your franchisees are doing something and you're like, wait a minute, they were trained. Well, no, maybe they weren't trained properly because the training wasn't sufficient. So now you bolster your training regiment or topics and things like that. And then we've talked about IP ownership issues. Okay, we've talked about also regulatory and contractual review, compliance, unauthorized franchise sales or renewals. I will tell you that in this moment, we have at least 2 franchisors who are going to the regulators in various states and asking for forgiveness for tripping over some wires, but barely tripping over them and not on purpose. And so there's an accountability for that. And because these franchisors self-reported before getting caught, then it's a better picture for them and it will likely result in a slap on the wrist. But you want to identify those kind of things so that you know, saying, hey, we're new on the scene for a buyer franchisor is not going to work. And so you know, and these various other things, non-compete clauses, are they enforceable? Were they drafted at a time when the law in the state of Kentucky allowed for a 4-year non-compete for employees? And now it's clear that a 2-year is probably the max. And again, I'm just giving a random example. I would say probably just, and again, I probably should have said this at the very beginning. This is not specific legal advice. There was a disclaimer on slide 1. I don't know if you saw it, but it basically says, hey, we are just providing guidance and we're providing some suggestions and that kind of thing. We would not be able to give you legal advice because we don't have an attorney-client relationship. And also we would not be able to give you specific advice unless we know the specifics of your situation in order to be able to do that. So disclaimer midway through, but rewind the tape and apply that to the very beginning. All right. Assess exclusivity or protected territory obligations, meaning that, okay, maybe there's uncharted territory that you've been, from the franchisor's perspective, chartering and thinking about, but maybe an opportunity to highlight that as being an asset that is being sold to the potential buyer. Again, taking a deeper dive into the transaction documents. Okay. Regulatory, we've talked about. I'm going to speed this up a little bit because I want to get to the franchisee's perspective as well, and I want to be mindful and respectful of everyone's time. So, Nick, if you want to kind of quickly run through this.
Yep. Thanks. So hey, this is just a quick rundown from the franchisee's perspective here, or in other words, sort of how to make sure you both know of and take action on your rights. Part of that, I think, is really, as you'll see here, documenting the transition from your perspective, which can help you in the future if you do have any legal claims related to the transition in particular. And first and foremost, I think we've tried to beat this pretty hard throughout this this presentation, but know your rights. Know your rights under your franchise agreements. Check to see if you have any sort of consent clauses where you do have a say with respect to any sale that may happen here. Organize your records. Make sure that you don't have any open defaults. And I know you just switched slides, Jack, but I want to make sure that one really hit. Sorry. Because just you may have a relationship with the old franchisor. It may be somewhat informal. They may give you a little rope on certain things or in certain areas. Just know that relationship may not continue. So make sure that you've crossed your T's and dotted your I's with respect to all of your covenants and everything going forward here. When you learn of a pending deal, request formal information. Quick plug for people like me and Jack: engage a franchise attorney to take a quick look at things just to make sure that you do know your rights going forward, and you can properly assess what you need to do going forward as well. You can more informally, you can do some due diligence yourself, really to research the buyer, make sure that they're doing everything, they are who they say they are, and that they're doing everything with respect to updating the FDD and state registrations and everything else. And during integration, here's where I think it's really important that if there are disruptions or anything that looks like it might be going off the rails, document it. Email to the old franchisor during the integration and transition, the new one. Make sure you've got those records, because when the rubber hits the road, you do perhaps need to pull the trigger on litigation. You will be saved knowing that you've got those records there. Post-closing, protection, same thing. Just a lot of the same things. If someone's requesting early renewal or amendment request, think about why and get legal review as to why they're trying to do that. And also try to participate on any councils you may be able to do that, just because you want to know what's going on.
All right, and I'm going to run through this pretty quickly. And again, the slides will be published, and so you can go back and review. But so this is kind of a bonus. I took a different perspective on this, and a lot of this is just, again, buyer seller is not necessarily exclusive in the franchise relationship, but when you talk about operator transactions, the seller should be looking at certain things, which is the franchise agreements with respect to restrictions, P&Ls, leases, any issues with defaults, tax implications, disclosure packages, pending litigation. What is the transfer process, both on paper but also just practical? What is the timing of that? And then we've talked about this. Look into things that are possibly out of your control with respect to bills of sale, assignments, lease transfers, personal guarantees that you forgot you signed way back when. that are still there with respect to the franchisor. It's one thing to terminate the franchise agreement on behalf of your entity, but you will want that to be also terminated, specifically the guarantees that you signed. And then B, it says comply with post-closing covenants, but first be aware what those post-closing covenants are with respect to the non-compete, non-solicitation, and certain other things. From the buyer's perspective, again, the opposite of that or converse of that, review the target franchise agreements, evaluate your protections with respect to territory and development rights, prior performance on your key performance indicators, pre-qualifying. Again, if this is someone that's already in the system, probably going to have a competitive advantage. Review lease terms, financials, the financing. Make sure that you are on good terms and in touch with your lender. I just was on a call earlier today, and person having issues with their lender, and it's not the banker's fault. It's just kind of what the underwriters are putting them through. And part of me says they might have anticipated that. Part of me says, well, it's just the way it is these days. And then obviously dealing with employees, the IP or the IT systems, and then performance. So again, just wanted to provide some thoughts on how to go about this very maybe better or properly. We do seminars on this stuff, like all-day seminars just on some of these subtopics. And so again, and there is the beautiful disclaimer that we are not providing specific legal advice. And I wanted
Spoken
to
like a
try to
true
talk really
lawyer.
fast. Yeah, like blah, 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 blah. And that's what it says. I feel like on a pharmaceutical commercial, right?
Yeah.
So that is where we're at, and I know we're at time. Nick and I are happy to stick around if people have questions. I haven't been monitoring the chat or the Q&A, but certainly happy to, or reach out to
Yeah.
us. If you have a specific question that you don't want to pose in the public forum, we're happy to do that as well.
We had a couple, and I'll just throw one out there here.
Yeah.
It says, how do you balance the need for speed in closing a deal with the thoroughness required for legal compliance?
I'll give you the transactional answer, and then Nick can give you the litigation answer, which is, yeah, I mean, they're obviously not mutually exclusive, but they kind of play against themselves. And we find ourselves saying, okay, wait a minute, what about this? What about that? So, for example, there may be a potential tax issue that has come up, and we need to look into that with North Carolina Department of Revenue or something along those lines. Or, we're hearing some thoughts about, well, the financials, maybe, something that's on the financials maybe is inaccurately stated, or we need to look into that. So we need to discuss that with our side of the CPAs and others that are on there. So yeah, and everybody wants to go fast, right? And so we're usually the bad guys that are saying, whoa, slow it down, until and unless our client says, I understand that, I appreciate that, but we need to close this by August 31st or else. And so that's the transactional answer. What do you think, Nick?
Yeah. From a litigation perspective, it's all about knowing your risk. So, when you talk about speed versus thoroughness, I guess you start where you'd start is how good has your system been up to that point, and that's kind of what you use as your baseline to justify or analyze risk. Look, there's always going to be risk, and obviously, if you go quick and dirty, that risk grows substantially. But if if you've got counsel throughout the process, particularly somebody who is aware of what can lead to litigation more frequently than other topics, you can then more accurately, assess where you need to spend your resources, so you can do so quickly while really just assessing the risks. Because again, we understand that in a lot of times that you want to move fast, and sometimes you need to move fast. So you're always going to have risk. It's just knowing where those potential soft spots are, being aware of them, and then moving forward. I mean, I think there's no context, I think, where I've been in it with a client that just, you can cross every T, dot every I, and say there's no threat of litigation. Listen, all it takes to start litigation is one person with a filing fee, and then, you're in court. So just, you're always going to have risk. I think just making sure you've got counsel to let you know that, hey, here's your risk, and then it's your business decision whether or not you want to go forward.
And Tim, I'll also put a question in there and answer it, which is at what point is it appropriate, or should we get a lawyer involved or get an accountant involved, a CPA involved? And a lot of times we will get a fully executed letter of intent, which it makes sense that, okay, well, we've negotiated the deal points. It's a letter of intent. It's not binding, so no harm, no foul. The challenge there is that you are indicating your intent on certain things. So it may be that there's an earnout formula in there. It may be that and it may be that the business owner doesn't necessarily understand the complexity of it, because there are, the formula says, well, if A then B, but if C then D, and thinking they understand what those variables are, which is probably the case. But what happens when there is a variation on those variables that creates a different outcome? And so what you don't want is the other side to say, well, you should have vetted that before, but now what you're doing is you're changing the deal in bad faith. And so that's why, it is important to seek guidance earlier on than maybe people think. And again, this is not a pitch for our services. I'm just saying, talk about legal pitfalls. That is one of them that tends to come up often, which is, trying to navigate around and legitimately change the deal, because that isn't the deal that one of the parties thought they were getting when they signed up the LOI.
Gotcha. I had a quick question. I saw a documentary on the guy who started Jimmy John's, and they built this incredible organization. The first 20 stores, they had 75 franchisees, and then his CFO came to him and said, "Hey, the 20 corporate stores are doing great. The 75 franchisees are failing terribly." Now, it was a whole story of how. And it could be the reverse on that. I've seen the reverse on that as well too, where franchisees, um, it's the other way around. How do you usually encourage like mediation, or how do you counsel folks when it comes to that versus somebody filing a lawsuit and then everybody lawyers up, nothing happens?
Go for it, Nick.
Um, I don't know if there's a really, really good answer for that. I mean, you just kind of have to like anything else, assess the situation and kind of make a determination just kind of out of the gate, right? I mean, when you're talking about the differences between corporate stores and franchisees, um, you can get into the weeds on those and kind of really start to pull apart the differences. Um, and then it becomes sort of a management kind of perspective issue. But I don't have something good for you, Tim.
Okay.
Yeah, and I would
Now,
say, Tim, that and kind of a different view of that is, and now I'm really taking off my legal hat and putting on my counselor's hat, maybe my psychologist hat. I am not a licensed therapist, but I sometimes pretend to be one.
but you stayed
So,
on Holiday Inn, that's
and
nice.
but exactly.
Yeah.
So it is a matter of understanding what's going on in the other person's head to the best that you can. Because a lot of times, and this is not just in business, this is in personal transactions, personal interactions, what is going on behind the scenes that we're not aware of. There have been so many times where I have felt that the other side was being unreasonable. And I'm like, okay, are they just ignorant, meaning just don't understand what's going on? Are they just being jackasses because that is their personality? So I have no problem calling up opposing counsel and saying, what is going on? And off the record, I'm like, what is going on? Well, he's going through a divorce. She's just lost her dad, and so give it a little bit of time, or might get that, well, that's just his personality and that's just the way he's going to be. And, you need to figure out how to to navigate around that. And I'm like, do you have any hints about that? And they're like, well, don't bring up this and don't say that word. And, don't make him feel his voice is not heard. Okay, great. Beautiful intelligence to be able to go and say, all right, and the way you negotiate changes. So I would say that, understand before you go all out on litigation is to try to negotiate that, because a lot of times I'll go to Nick and say, this is what I've done, and this is what you need to know about the other side. This is what you need to know about opposing counsel. They are not going to be helpful. In fact, it may actually be opposing counsel that is the problem, that they want to get as much as they can for their client. And if we were able to, permitted to ethically get their client in a corner or in a room and say, what do you really want? Well, I just want these things. Well, you have a list of 4 things. Why is your attorney asking for 10? So it's those kind of things. So there's a lot of psychology that goes on in that process before going all out, guns blazing.
Gotcha.
That's a good point,
Yeah.
Jack. Sometimes we can get in the way of the clients too. Not us, me and you specifically, but you're right. That's something that I'm dealing with even today, where yeah, right, an attorney thinks he's representing a client in the best interest of the client, but there's a deal to be had behind the scenes.
Yeah. No. Well, hey, I know I want to be respectful of everybody's time, and so I'm gonna close. But I want to thank you guys for coming on. I know that's a lot of stuff. Franchise transactions can be complex. They can be, risky. But with the right legal strategies, you can protect yourself, your brand, and foster stronger franchise relationships. So if anybody has any questions, please feel free to field those to myself. We can also forward those on to Jack or Nick. And just on behalf of our presenters and everyone here at Dominion Payroll, we just appreciate you joining us today. And hope that you'll join us for the next webinar. Have a great afternoon.
Thank you all. Thanks, Tim.
Thanks,
Thanks for having
guys.
us, Tim.
Thanks, Nick. Thanks, Jack.